will be recorded for your purpose. So you could have access to the document, to the recording nearer to the exam. So yeah, I'll tell you what we're going to cover today, uh, Lord Chi. Yeah. So the plan is to go through some slides, talk about what you've discussed. Today we'll be looking at section 12, the right to transfer title. And after looking at the slides, I'll be taking you through some exam questions and we'll be answering that together. And that will be something that'll be useful for your assessment. But before we get into that, I need to introduce myself. So I'm Fatima Opebi. I'm a Doctor of Law. I got my PhD at the University of Manchester, and it's in financial technology law, and my master's was in international commercial law. So that's the area I'm a bit familiar with the area. So welcome everyone to the revision lectures. We're going to be answering some questions together, and hopefully that will help you in the assessment so you're able to um, make the best of it and excel in your exam. So we'll be having a 3-hour lecture per day from today, tomorrow, Thursday, Friday, and then next Monday. Now I know it's at 11, not at 12, as I thought it was going to be. So what time is it in Hong Kong? Uh, anyone wants to tell me what time it is? Oh, 7:30 p.m. Okay. Yeah. What's the weather like? It's sunny here, clear, no rain. Not too bad. Good. Good to hear that. So, yeah, nice weather. Yeah. Hopefully we're all oh, okay, great. Yeah. Yeah, thank you for letting me know that. So going back to what we'll be talking about, I said we'll be going through the slides. We'll be answering some questions together, and I'll be telling you what kind of question that will be in the assessment. I've just made a note of that here, just to let you know if it's going to be a problem question or an essay question. I've been told you'd really be interested in something of that nature. So I'll be telling you that. And more importantly, we're going to be looking at answers that have been answered by students in the past, and you will be guessing the grade they got, and that's just to help us see how much you understand what is required of you in the assessment. And I'll also be telling you some of the things you need to do to make the to earn the higher marks in the assessment. So I just want to see if there's anything I've missed here. Okay, so thank you for that question. I'm bringing up my document here to see what that is. I know today we're looking at section 12. If we finish early, we will be looking at sections 13 and 14, but I don't think we'll cover that uh, or that much today because we're also going to be looking at the questions, the assessment questions, and then answering that together. Not this assessment, not this one, previous questions. So section 12, sections 13 and 14, that will be the second topic. And the third topic will be SGSA. The fourth one will be the NEMO that topic. And the fifth one will be property and risk. And the sixth one will be exemption clause. So did you get all that? So section 12, sections 13 and 14. And next we'll be looking at SGSA, supplier of goods and services. And next we'll be discussing, I'm looking at my notes here, NEMO dat. So NEMO dat. followed by property and risk. Yeah, and then the final topic will be exemption clauses. Yeah, very good point, Lord Chi. Yeah. So that's why I said we will be. Oh, I hope I'm not. I think I'm sending all that to one person, so I need to copy. I think he just highlights one person, section 12, sections 13 and 14, section SGSA, Nemo that property and risk and exemption clauses. So is that okay? Should we start? Customers, consumer, you mean B2C? We're going to see that no, I don't think I should be telling you that. That's part of the thing examined that will be examined. So you're going to look at a question and you're going to be able to interpret whether it's a B2C or B2B contract. Do you understand? So that's to Twin Shong that you're asking if there will be a question asking about B2C, right? Yeah. So I just want to say we'll be going on break. What is the topic for the exam question? If you want to ask me a question, can you just ask to the main room so everyone can see your question? I'm getting a direct message here saying what is the topic for exam questions. We're going to, I think in the assessment, you have questions on Consumer Rights Act. You have questions on I'm trying to see my, yeah. So you have a question on CRA, Consumer Rights Act. You have on sections 13 and 14, section 12, SGSA, risk and property. So everything we're discussing is quite relevant to your exam. So I would advise that you pay attention to what we're talking about. So can we start now? Have you got any questions before I proceed? I'm taking your silence as we can start. So I'll start sharing my. So yes, this is being recorded. It is being recorded. Yeah, I've clicked the recording button. So it's being recorded. Yeah. So I want to see with this share screen sharing option, I can't see the chat anymore. So from current slide, I'm trying to bring up the chat. Okay, yeah, I can see it now. So you can see the slides. Yeah, you're going to pick 3 out of 5 questions, and I'm going to tell you the makeup. Okay, the makeup of the questions are 4 problem questions and 2 essay questions. As we go through the past questions, I'll tell you which is which, so you'll be able to make sense of that as we start our discussion. So yes, let's get started. Um, revision lectures, commercial law. The first topic is sale of goods, section 12. So we do understand that the Act, the 1979 Act, or whatever discussions we're having here, centers around the contract of sale of goods, which is a contract by which a seller actually transfers or agrees to transfer the property and goods to the buyer for a money consideration called price. And I see many of you in answering questions, many of your predecessors, those who did the exams last year, 2 years ago, they started with this. They give us that definition and they say, in this scenario, this is a contract of sale of goods in the sense that there is that agreement to transfer, or there's a money consideration called price, and there's the issue of property. So some of the students do that, which is very good. So if you can just touch on that in answering your questions, you can do that by all means. So you can see from that definition, it's not just when you transfer, it's when there's an agreement to transfer as well. So in a contract for the sale of goods, there has to be goods and there has to be price consideration. It has to be money consideration. So we've got other types of contracts that are different from sale of goods, but and are not governed by the Sale of Goods Act. One example is the hire purchase contract, is the barter contract, etc. So those are not covered by the definition of a contract of sale of goods. There has to be all those consideration. So as I've said before, a contract of sale also includes an agreement to sell as well as a sale. So it doesn't matter that the contract is executory in the sense that it happens in the future. All that matters is that the contract has that agreement. People plan ahead of time. In fact, that's what happens most times. People don't just enter into the contract and execute it immediately. It could be executory. So moving on, Section 55, the definition section says where a right duty would arise under a contract of sale. You can negative, you can contract out of the provisions of the act. You don't have to um you don't have to let all the provisions apply to you. So you're able to contract out of that. Now, the freedom to contract out of it has been restricted greatly by the Unfair Contract Terms Act. And the question is, why would that be the case? Why does the government want to interfere and ensure that people are not people are contracting out of the act, or people are not able to contract out of it? Looking at the definition of the 1977 Act, this is an unfair contract terms act. There's this concept of unequal bargaining power that we talk about when we're talking about the sale of goods. So if the law sees that one party has got more power, that means they're able to force their terms on the other party, and that's why we got this Unfair Contract Terms Act. So that act prevents the ability to exclude some provisions of the act. So yes, that's what that's all about. So goods, what are goods? You're going to see in the assessment that the questions we give you are in relation to goods. So rest assured with that. So goods could be chosen in possession, things you can possess, things that can be held. It could be specific goods. It could be uncertain goods. And you know when goods property cannot pass on in uncertain goods until they become ascertained. So that's also included. And future goods, goods that do not exist at the time of the contract, or goods that do not belong to the seller at the time of the contract, also are included. What's not included is choices in action, your check, your bills of exchange, etc. Those are not goods and they're not covered by the Sale of Goods Act, or what we're talking about here. Now, you might ask yourself, why do we need to have contract? Why is it important to have a contract? And the answer to that is if you have a contract, you can have peace of mind knowing that that issue has been taken care of. And the only thing you need to do as a seller, as a buyer rather, is to sue for non-delivery of specific or specific performance. So if you've contracted for the sale of computers, an executory contract, something in the future, and that computer is not delivered to you, you're able to sue the seller for non-delivery. And in that case, you can obtain damages for the failure of the seller to deliver. Or you can also ask for an order of specific performance, which means that the court can tell the seller to deliver those goods to you. And that's only possible because there's a contract for that. And you might think, why do you want to go through the hassle of asking the court to deliver goods to you when you can get the goods elsewhere? In most cases, you'll be able to get the goods elsewhere. But what if it's a rare good, maybe a rare car, a 1922 Chevy or a diamond chain that is now very expensive. So because there is that contract, you're able to sue and get that, even though the seller may not be motivated to sell it to you at that time because they could get a higher price elsewhere. So you may sue for non-delivery or specific performance. And if the seller delivers to you and you fail to accept delivery, the seller may sue you for non-acceptance or for non-payment. So that's the reason why you need to have a contract. And goods may not be of the right quality or fitted badly. And that happens a lot in the online market. You're buying something, it's delivered to you. You're seeing that what you ordered, there's this joke on the social media that people would say, what I ordered versus what I got. And you're thinking, this is very different. When you're looking at the pictures online, they're really looking glossy, really looking beautiful. But when it's delivered to you, it's something else entirely. So you may want to get your money back. You may also want to return the goods. You may want to repair. And the importance of contract is also to the fact of who is the owner. So you're asking yourself, who owns the goods? So if there's a contract and the date of the contract has passed, you become the owner, even though the goods have not been delivered to you. So that's why it's important to have a contract. Who is the owner answers the question of who has the risk if there is a damage, and it goes to the issue of passing of risk and property. And you also may want to sell on, even though you do not have possession of the goods in question. So those are the reasons why it's important to have a contract. If you have any questions as we're discussing, as I'm talking through the slides, let me know and I can quickly answer that before we proceed. So we need to try to distinguish sale of goods from other transactions because it is only by doing that that you will know the law that applies to the question at hand in your assessment. You need to be able to know, reading this question, is this a sale of goods? Is this a hire purchase contract? Is this a gift? Is this a bailment? So, contract for works and materials is very different from sale of goods. That is covered by the SGSA. So, the main ingredients of the contract is the skill and labor of the or supply of the good, the skill and labor or supply of goods. So, if say you've employed a plumber or a carpenter to fix your furniture, and yeah, I think there's a question here. Bailments will not appear. That won't appear, Wong. So thank you for that question. So you're not getting any question on bailments. There might be something on hire purchase, but that's not testing your understanding of hire purchase itself, but testing your understanding of maybe the NEMO that principle or Section 12. So you're not, the main questions you get will be on SGSA, Section 12, etc. So I hope that answers your question, Wong. So contract of work and materials is different because you're relying on the expertise of that contractor. You're relying on the expertise of the contractor. You're not asking, you're not buying goods because you could do that yourself. And even there are some goods that you can buy that do not are not relevant to you, if that makes sense. So you need someone, they're not relevant to your expertise rather. So you need someone that knows about the goods to get that for you. So if you're not in the business of fixing cars, why do you want to buy a car engine? So you need someone else to buy the car engine. And you're also asking them to change the engine of your car. So what that means is that you're not buying the engine itself, but you're giving them a contract to replace the engine of your car. And part of that contract is to buy an engine. We're going to talk more about SGSA. Now going to the contract of hire, that is covered by a different law. So it's not the same as sale of goods. Hire means you own something and you're giving it to someone else to use or to yeah. And what that means is that ownership is still in you. But with sale of goods, ownership transfers to the next person. So gifts, there's no price consideration in gifts. So it's given freely. Bailment, this is someone holding your goods on your behalf. Property again is not transferred. So we see the distinction and it's important. I don't see this as a problem because I don't think I've ever come across a question where a student got it wrong. Good job from your end. Students know when you're looking at the answer on SGSA, they know it's an SGSA question. If it's a sale of goods, they get it well. On rare occasions, you might see a student misinterpreting what's it called, B2C and B2B, but a vast majority, say 99.99% get it right. And even if you read the question well, you see hints, you see indicators that tell you that this is the kind of contract in question. So I'm not worried about that. And I don't think I know you're very good about with this. So now, the Consumer Rights Act is the legislation that applies to business to consumer contracts, while the SGA is the act that applies to business contracts. So the CRA applies to consumers. And when you're talking about the CRA, you will do well to highlight that gives more protection to the consumer than your business. So we talk about this thing called unequal bargaining power. So what's the really here in the UK? I know you might have that as well in Hong Kong. We have Amazon. Amazon is a really good large retailer. I don't know. Do you also use AliExpress? Or what is that really large retailer, online retailer that you use in Hong Kong? Can you tell me that in the chat? Taobao. Okay, yeah. So thank you for that, Lord Chi. Okay, Taobao. Okay, great. Now I want to ask you, are you able to negotiate with Taobao? Can you tell them this is what I want and this is how much you cannot. Goodly good. So it's because of that unequal bargaining power. So they're very large, they're quite big, they've got lots of money, lots of lawyers, lots of the good stuff, lots of resources. And you're here, I am here, trying to negotiate with them. So just imagine if we don't have that extra protection and you bought something from Taobao and there's no law forcing them to do the right thing, you've got nothing. You've got nothing, right? So that's why we've got this Consumer Rights Act. It's there. Thank you guys for engaging. So that the Consumer Rights Act is there to give that extra protection to the consumer. It's there to give that extra protection to the consumer. And what you see is that it's better for the consumer if you rely on that. So going to the CRA, it says For a trader to supply goods, that is what it covers. And Section 2 defines trader as someone acting in the course of their business, trade, or craft. So they know so much about that business, they have so much knowledge, and they're able to exploit you if they're left to it. So Section 2(3) defines consumer as someone acting privately. They're not acting in the line of their business. And consumer is now clearer when it comes to um, B2C contract. And to make things easier for consumers, the Consumer Rights Act does not just cover sale of goods, it covers sales, hire, hire purchase, and transfer of goods. And just to make it that repository, that document consumers can always consult when they're engaging, they're doing business with a trader or a hirer. So now let's go into the meat of this. That's all the preliminary. Like I said, many students define contract, sale of goods contract, and that's good. It just shows you know what you're doing in the assessment. So the focus of today's session is section 12, the title, the right to sell or supply. And that's provided for in section 12 sub 1 of the Sale of Goods Act. This section has got two key aspects that if you're answering a question on this in the assessment, you will dedicate much of your time to talking about this subsection, subsection 12, subsection 1. But you also must not forget to talk about the second subsection that I'll get to in a moment. So this section provides that in a contract of sale, there's an implied condition. So you see, it's a condition. We'll get to that very soon, but condition is that higher level term that has to be complied with. If it's not complied with, there could be devastating or really key implication of that on the seller. So there's an implied condition on the part of the seller that in the case of a sale, he has the right to sell the goods. See here, it doesn't say he has the ownership. No, he has the right to sell the goods. And that's because you may be able to sell something that does not belong to you. So what is required here is that you have the right to sell the goods. And in the case of an agreement to sell, you will have that right when the time for property to pass arrives. So we're going to break that down. I know we have another question or another topic on NEMO-DAT, and I want to distinguish between the two. So section 12 implies a condition that the seller has a right to sell. So it doesn't have to be the owner. So if you're talking about section 12, you're applying the cases of NWS and Barker. You're applying the cases, we're going to talk about the cases. You're not applying the NEMO-DAT because NEMO-DAT speaks to who owns the goods. So who owns it? Say someone with no right to sell has sold something, who owns it after such sale? But section 12 is talking about that being a condition, the right to sell being a condition. So one is about after sale, and the first is about before sale or during the sale, if that makes sense. We're going to see how that plays out very soon. So we've got different factual scenarios that could demonstrate the overlap with the right to transfer property, which is NEMO-DAT. So in this case, there's an owner that has his item stolen by A. A sold that property, that goods, to B. B sold it on to C, and C now sold it to D. So what do you think will happen if the owner sues D? What will happen? Yeah, I'm just reading your comments. Yeah, you're right. They draft standard terms and conditions, and that's because they're all about their profit. They want to make profit and they just want to crush everyone. So what happens if the owner sues D? What do you think happens? So Nemo that might intervene, you can't give what you don't have. But we're not going to be talking about Nemo that if the question tells you that you need to, yeah, good. We're not talking about Nemo that if the question is asking you about Section 12. You may touch on hire purchase exception, Section 27, but that's about it in this question. But for the other exceptions to Nemo that, you will see another question on Nemo that. So you may sue for conversion. I like you. You guys are really top notch. I like the answers I'm seeing here. So D will sue C, C will sue B, and B will sue A. Very good. Thank you for that one. Or sue for conversion. That's also an option. Very good, guys. Now, when this happens in reality, A is often A is often not found because he's a rogue, isn't he? He stole the item, sold it off, and it would disappear. So some we have innocent parties here. The owner, B, C, and D. You won't find A. That's what happens in most cases. A would have taken off. It won't be found. But I like your engagement. Thank you for that. Now, what if goods subject to a higher purchase? So that's a different one where you won't find the rogue. In this case, the owner, the higher, I mean, the higher purchase owner, they own the goods and they've given it to someone else on higher purchase. So when this happens, the yeah, so when this happens, the hirer, H, will have possession. So it's a car. The hirer will have the car. The H will have the car, but the ownership of the car would be in O. So it is until H pays off and buys the car at the end of the hire purchase agreement that he becomes the owner. But now he has transferred the car to D, and D has sold to PB, and PB has sold to X. And the question here is who should O sue? Who should O sue? What do you think? I'm waiting in the comments. Okay, very good question, Wong. Very good question, because that's what will determine what the rule is. So let's assume or sue X. Yeah, yes. So we're going to get into that very good question, but your thinking is in the right place. Oh, bona fide purchaser. So that's a very good example of some of the exceptions that could apply, and that's going to be what we're talking about in a moment when we're looking at the questions. So key questions will be O can sue X. And why would you want to do that? That's because X is the one that has got the car. If O sues H, H cannot get him the car back because he doesn't have it. So if O wants the car back, it needs to sue the person that has it currently. But there are some exceptions that could mean X could get title. Bona fide purchaser. I like all the comments I'm seeing. Good. Now, let's move on to the next slide. We're going to be answering that question, who should OSU in their revision questions. But let's move on to, does an owner always have the right to sell? Because we've talked about if you're not the owner, that's a no-brainer. It's possible you do not have the right to sell. But if you're the owner, why shouldn't you have the right to sell? And it was a case of Niblet and confectioners materials that shows us that even though you're the owner, there might be some restrictions that prevent you from being able to sell. So in this case, Niblet was using the name Nestle, and Nestle sued them for passing off, and they were able to obtain an injunction preventing Niblet from that prevented confectioners materials from selling that property. And the court said, even though you own the goods, you do not have the right to sell. So there has been a breach of a condition. So it doesn't matter that you are the owner or not. What is material is, do you have the right to sell at the specific time? Do you have the right to sell or not? So what are the remedies for the breach of Section 12? We said it is a condition, didn't we? So what are the remedies for the breach of a condition, guys? What happens if a condition has been breached? Because you will be talking about this in the assessment. So let's damages. So damages is a really good one, even if it's a warranty rescission. Yeah, you can repudiate the contract. You can rescind the contract, and what that means is that you ask for your money back, all of it, and you could also sue for damages. Those are the two things you you can do in that situation. So thank you for that. Those are the remedies for a breach of a condition. Is the higher level of terms in a contract, is the highest level of term you can breach. Some people say they are fundamental terms, but those have also been classified as conditions. So that's not very material to for our purpose. So now, what is the basis? What is the reason why the buyer should be able to recover the price? Some people said it's because of total failure of consideration. So you've contracted to buy a car, you've contracted to buy a gold wristwatch, and you've been given that. But after a while, someone else is chasing you and telling you, give it back. It's not yours. Give it back. Give it back. And what we say is that you really did not get what you want. So I want to ask you, do you think this is true? Is that total failure of consideration? Because this has been open to criticism by people. People have argued that's not really true. What do you think? Do you think there has been total failure of consideration or not? If you contract to buy a car and you've only been given that car for say 9 months or 6 months or 2 years before the owner comes chasing, do you think that's total failure of consideration, or do you think no, there's something there. You've got something and you should be made to pay for that thing. So what do you think? Yeah. So then, yeah, some people agree with you and say, oh, isn't that unkind to the owner? Because the buyer has used the car for a while. And I like your argument, Wong. The usage is ancillary. So now, to elevate your performance in the exam, the way you distinguish yourself as a student is to bring these arguments. There's the argument that he has used the car for a while, so he has gained some benefits through that contract. And you now want to contrast that. You want to counter that argument with what Wonga said here. But the only way you will be able to counter is if you raise the first argument that the bias used the car. So is that not unjust enrichment? Is that not unjust that the buyer has gained something from the contract? But the argument you brought there, Wong, that the use is ancillary, that's not what they wanted. Using something, you can use something through hire purchase, you can use it through hire. But if you want to buy something, you want it to be your own. And that's why the argument for total failure of consideration is valid. So if you get what I've done there, we've looked at the law, and then you've brought arguments on both sides. And that's the analysis. That's the criticality we're looking for that top end answers, your 70s, your 80s, your high two ones. That's what we're expecting. You're just not going to tell us what the law is, the conclusion. Tell us how you get there. Do you understand that? I'll be telling you more of the things you need to do, but yes, we want you to engage with the cases like what he has cited, the Roland and Duval, and the other cases as well. So, very good. That's the next slide, isn't it? In this case, there was an owner whose vehicle was stolen by someone. So, stolen, the defendant and then sold it on to the claimant, and the claimant sold it on to the buyer. So the car was repossessed from the buyer. The claimant returned the money to the defendant, and the claimant returned the money to the buyer and claimed money from the defendant. And the claimant was successful because the defendant had not provided any consideration. So, what distinguishes this section? It's the core section when it comes to sale of goods. If you don't have the right to sell, you don't have the right to anything. So, you cannot claim that there has been acceptance. No. So, acceptance could work. You can say, oh, they've accepted for sections 13, 14, other breaches of conditions or warranties. But you cannot do that because it's a very core principle. You need to have the right to sell. If you don't have the right to sell, you practically do not have anything and you're entitled to nothing, not even for the ancillary use of the item. And like I said, people have criticized Roland and Deval that why is it so important? Why is the law so strict? Why is this treated differently to breaches of sections 13 and 14? Can we really say there's a total failure of consideration? So these are some of the questions you can ask in your answer to show that you are engaging with sources. And in doing this, you may want to refer to the law reform. There are some articles that have been written about this. And these have addressed the question of should we make the buyer give credit for use of the vehicle? Should we make them give credit because they've used it for a while? And you know the way vehicles are, the more you use it, the more it depreciates in value. So the value would have depreciated. And there are even some cases that say that if the buyer has paid to repair a vehicle or the goods, they can claim for what they've added to it. I'm checking the time to be sure that I'm releasing you to go on break when it's time. So there are some criticisms of that. You will do well to bring those up when you're answering the question on this. The main argument is there is total failure of consideration, and that's the authority, Guido van der Gaard, that you have contracted to buy some goods. You have contracted to buy some vehicles, but you didn't get that because the owner wasn't the one that passed title to you, so they couldn't pass title to you anyway. So why have you bought the vehicle? Is to have it, is to own it, but that's failed. So you can use Guido to explain Roland and see why courts have been very consistent in their approach to this issue. So there is also the other issue of feeding the title, and that's very relevant to the issue of hire purchase. So say the hire purchase company is owed money by the buyer one because he was still paying his installments and he was owing them, so he couldn't have ownership of the vehicle. And then he passed the car on. What if he pays for the car and then that means the ownership is transferred to him and he's able to transfer ownership to B2 and B2 is able to transfer ownership to the defendant who can now transfer it to the claimant. So that's what we call the feeding of the title. So in this case, in Butterworth and Kingsway Motors, the court said, yeah, because he rejected before title is fed, he was able to claim for the breach of section 12 because when he rejected, he did not have the title. But now there's another question of what if it was before title is fed? It was it was after title is fed that the claimant rejects title. So what would happen if the buyer got title despite the seller having? So this is another question. I'll come back to the first one I was asking earlier. So remember, under Section 27 of the Hire Purchase Act, and that was a question asked by, I'm not sure if it was Wong or someone else earlier, that you're able to get title. It depends on who the buyer is. So if you're a private purchaser, the first private purchaser under a hire purchase agreement will get good title under Section 27. So if in this case the first private purchaser gets title you're able to get title, right? And the question is, are you still able to reject? We have buyer's remorse. You've bought something, you've used it for 6 months, you're thinking, I need to buy another one. But now you've been told, oh, there was a defective title. I could return it. You're happy about that. But they're saying, no, no, cool down. You cannot return it now because you've got title under Section 27. The question is, can you still do that? Can you still do that? So if you're applying Butterworth, you need to point out that the situation has now changed under the 1964 Hire Purchase Act. So you're able to get good title, but we don't know if you're still able to reject. And the argument for you still being able to reject is if there is a doubt or there is a blemish on the title of an item, it will be difficult to sell that thing on. People don't want to touch that. People don't want to buy something that is problematic. So it is fair if you're arguing that the buyer should be able to return the goods, because why didn't he pay up the higher purchase sum before selling it on? So there's that argument. And there's also the other argument that you've used the item. If you want to reject at that time, that title has been fed to you, it should be debited for the time you've enjoyed. But what the Law Commission said was that's a very difficult thing to account for. It's very difficult to account for your enjoyment for that period of time, because that's not what you contracted for. What you contracted for was to get the goods, to buy the goods, to become the owner of the goods, not to have that issue with ownership. So you see, it's just those problematic aspects of things that we want you to shed more light on in your question. So we're asking you to engage with the difficult aspect of things. Don't gloss over it. Raise all the valid questions. Attempt to answer them if you're able to. But this is how you distinguish yourself. It's not by describing, oh, there's an MODAT principle, there's a Section 12. Yeah, but what are the main issues arising from this application? That is how you distinguish yourself. We're going to see how that plays out when we're answering the revision questions. But I just wanted to know that to elevate, to really do well, to have the higher grades, you need to address the problematic aspects, the difficult aspects. You need to address those. So, um, yeah, I think this was one I was looking at. So the owner gives the car on a hire purchase to A, the hirer, and A sells this car on to B, a car dealer. We know that the dealer cannot get property, cannot get ownership, because that's not, yeah. But if this dealer B sells it on to C, that's the first private owner. They can get ownership under Section 27. But what if the buyer, the claimant, was still able to reject the car? What if they're able to do that? In Barber, the court said yes, they are still able to return it because it was a breach of Section 12. The law has not reconciled both. So you as a private seller, you're still able to reject. And that's one of the problematic areas of it. Like, why are you still applying the law when why are you still trying to reject the goods when you know you've got good title? Now, what is the breach of Section 12 and Nemo that? What's the connection between the two? So aside from Section 27 exception, as a buyer, you will still be able to recover for breach when you can I mean, can you should you still be able to reject if you can acquire title by maybe owner, some of the exceptions, or sale by an owner in seller in possession, buyer in possession, and the other exceptions. Are you still able to do that? That's a really good question. And the people have questioned why there's a distinction between all of this. So that's all the rights you've got under the SGA. There are similar provisions in the Consumer Rights Act for consumers. And anytime you're applying the Consumer Rights Act, you want to think about what is the law giving here? What extra protection is the law giving here? So it's more expansive under the Consumer Rights Act. You've got more rights as a consumer compared to the Sale of Goods Act. It's online because I checked it. I Googled it myself before the session. Just copy that section and paste it. What they said, what the Law Commission said was that it's difficult, that it is not fair that the buyer could get all his money back even after he had used the car for a while or used the goods for a while. But they said it's really problematic. It's very difficult to assess the price, the costs that you can say you want to put on the buyer being able to enjoy the goods for a while. That's what they said, but it's very good practice, Lee, to get yours. Go online, search for the law commission. You'll find it on Google. Yeah. So back to the slides. So with the CRA, Section 19 is a relevant provision that says the right to reject is not limited is not limited to the 30 days. You have that. Within 30 days, you can say, I don't want this anymore. But beyond that, if the breach is a breach in relation to non-owner selling, someone that does not have the right to sell, there is no time limit. It's not limited by that 30-day limit. There no price reduction. Remember, the CRA is trying to give the consumer more rights, not less rights, not fewer rights. So there's no price reduction. You're getting all your money back, and it doesn't state whether what happens if title has been fed. So the assumption is that you are still able to reject, even if title has been fed. And that's what the question is. The first one is, okay, if it's a non-hire purchase contract, there's a different rule. You do not have to keep it. You can return. If it's a hire purchase contract, maybe you get good title. And this one, we're talking about Consumer Rights Act, and we're saying no, there's no provision for that. So it looks like the consumer can do whatever they want. They can return it. Um, if they've used it for a while, nobody cares. The question is, why did the seller sell in the first instance? So this is a very interesting question raised by Atia, who said that say Arnold buys whiskey from Bob or something that is consumable, and he drinks it. Remember, the goods are no longer existing, and he discovers that Bob never owned it because he was a thief, because he bought it in good faith from a thief. He wasn't a thief himself. Can we say there has been total consideration of total failure of consideration? Can we say that? What do you think? I mean, he drank the whiskey. There's nothing left to return. Is that total failure of consideration? You can contribute in the comments, please. Yeah, due to lack of purpose of contract, how can we assess? Yeah, yeah, absolutely. You can say that and say, yeah. How do we know? How do you return it? You want to say there's a lack of purpose, but it's a whiskey and he has drank it. I mean, drank it. So can you return it? That's a very interesting point to think about. So what if it was a business to business contract? What if it was a B2C? And we can have some inspiration looking at section 20, subsection 7 of the Consumer Rights Act. It just gives the consumer more power, more rights. So this is why I said when I talked earlier about when you're answering a question on section 12, don't just focus on section 12:1 and not talk about this? This is also very relevant. There's a warranty. Remember, warranty is a lesser term, which means that you cannot repudiate the contract. You can only claim damages. So there's a further warranty that the goods will remain free of encumbrance, not disclosed to the buyer up to the transfer of goods. So if you buy something, a car, and then someone's chasing you around saying, yeah, the person who owns the car is owing me money, you can sue for this. So the buyer must enjoy quiet possession of the goods, except they've been made aware that there's an issue. And this is also provided for in Section 17 for B2C contracts. And we have the case of Mason and Bonningham, where the owner recovered possession of a typewriter. So that typewriter was stolen, and the claimant, and was sold on to the claimant. The claimant paid money to repair the typewriter, and they were able to recover it, but also because her quiet enjoyment was affected, she was able to claim for that implied warranty. So you may have two claims when a breach of Section 12 has happened. The first one is the breach of Section 12(1), when that's repudiation, that's a claim in repudiation as damages. And you can also have a claim for damages, which is a warranty, and that's what Mason did in this case. Now, if you look at the previous section, subsection rather, it says except as otherwise disclosed. So you're able to tell the buyer that, yeah, I've got a defective, there's someone that is stressing me about this thing. If you made that clear to them, the buyer cannot come back to say, yeah, you've breached your you breach Section 12. You've already been informed, you're aware of it. So parties can sell only the titles they've got if they made it clear. So there won't be a breach of Section 12(1) if the seller explains that it has only limited title. So all charges known to seller are disclosed, and the seller will not disturb the buyer's quiet possession. So you need to let them know, and you also must not disturb their quiet possession. It's still a breach of warranty if you let them know. Don't disturb that. It's part of the sale contract. Now, one of you mentioned the remedies. You can sue in tort for conversion, and that will be under this Act, Tort Interference with Goods Act, 1977, where you can sue not just the person that stole the goods, but every other person that's dealt with the goods since it was stolen. So you can sue them, but because it's a tort, you're only getting damages anyway. And you can also get an order of specific performance or yeah. So in conversion, the court will assess the value of the claim as at the time of the conversion. So how much is it worth when it was converted? And you as the buyer, you have to weigh your options. You think about what are the benefits of suing A, what are the disadvantages of suing A. If you see B or C or D, what will you get? And the best thing you can do is to sue the person that has got the goods, because there's an option in Section 3 of that act to return the goods. So if you're suing the other people, they don't have the goods to give you anyway. So why sue them except you just want to get the damages from them? So in tort, if the defendant has improved the goods, then you have to give them credit, and that may be the reason why you don't want to sue under this act, compared to if you're suing for breach of condition or under Section 12, you do not have to give credit for what they've done to the goods. So yeah, it might be good on paper if there are no um, improvements to the goods, but if there is any, you do better to sue under Section 12. So that's all for the slides. Now I think the next thing we should do is to have a look at the question we'll be answering. So we've got two questions. We've got one essay question, and we've also got one problem question. So I think we should start with the essay question just to gain the habit of doing that and to help to show our understanding of the act. Not the act really, but uh, can you see my screen? No, you can't. Yeah, I'm just trying. So I'll come to your questions very soon. I'm just trying to bring it up now. I'm just trying to, yep. So slide, yeah. S Share screen, revision questions. It looks weird here. I don't know why. Okay. I think it looks better. Trying to, so revision questions. You've seen the first one. Assess the need for reform of Section 12 of the Sale of Goods Act. I think with this question, we'll be having a look at, should we start? You joined 1 hour, 20 minutes ago. So I think we should just do 20 more minutes before we go on break. Or what do you think? You do not have to answer any questions. You choose the questions you want to answer. And like I said, you've got four problem questions and two essay questions. So if you don't want to answer any problem question, any essay question, you're able to do that because you can just choose from that four problem questions. And if you don't want to, if you have to answer a problem question really because you just got two essay questions. And I think from experience, students like answering problem questions. So that's why I put four there. But I know that there are some students that like answering essay questions as well. So it's a difficult balance to maintain, but yeah. I'm going to be telling you at the end, after answering each of the questions together, I'll be telling you what it is in the assessment. If that's okay, Lord Chi. Yeah. So I'll be telling you when we've answered the question. So this is a question. It says assess the need for reform of the Sale of Goods Act as amend and 1979 as amended. Now I want to ask, I'll turn off my camera now. I want to ask you, what are the main things you will be discussing if you're answering this question as an essay question in the assessment? What are the main things you'll be discussing? What are the main cases? What are the main issues you'll be talking about? I know you may be tired, but just bear with me. I'll let us off in. Okay, exceptions, no. You're going to touch on one of the exceptions, but which is the hire purchase Section 27 exception. But if you want to discuss exceptions, that's what you do with the Nemo that question. So you'll be talking about right to reject. Good. Very good, Leeming. You'll be talking about what the rule is. The starting point is Section 12(1). What is the provision? You can summarize it because we know it's an open book exam. You've got the statute, so it makes no sense regurgitating the statute, but you will be summarizing that and saying this is what the act provides for. You'll be talking about the purpose of the rule. Why do we have the rule? So what else? So you summarize section 12, 1 and 2, yeah. And you also talk about the purpose of the rule. Why do we have the rule? So what other things will you be discussing if you're answering this as an essay question? What are the things you'll be discussing, guys? Let's do this together. What will you be discussing? What cases? Can you hear me? I can't see anything in the chat. Yeah, Roland versus Deval, very key. That's the main authority. Yes. What other cases? All of the cases have been cited in the what's it called? In the slides. So those are very useful. So Roland versus Deval, Butterworth versus Kingsway Mottos. What other cases? What other cases, guys? Barber, very good. Very good. So let's get started. Eric, yes, yes, very good. Thank you. So if you're looking at this question, you you start with the section 12, and tell us that it says summarize it. And section 12, 5A makes it a condition. That's very key because if it's not a condition, you're unable to reject the goods. So you being able to reject the goods is because this is a condition, right? So you're going to say section 5A provides that this is a condition. They're able to repudiate the contract and claim the price. And not just that, what else are they able to claim aside from the price? What else? What else are they able to claim? Yeah, they could they don't want delivery. I don't think they want that because the seller doesn't own it anyway. Right? Does that make sense, Lee? You want to return it. You don't want, yeah. So those are not or they're not return. Yes, you're able to return it. But what I was looking for from you guys is damages. So not only are you able to return and get your full price, you also are entitled to damages for that failure of total failure of consideration. So you want to start by explaining that this section relates to the right to sell, and it can be contrasted with the rules that relate to passing of property, um, passing of legal title. So under section 12, you as a seller do not need to be the owner. You just need to have the right to sell. And remember when we're looking at the case of Niblet, we saw that even the owners may not have the right to sell. So ownership has got little to do with the right to sell. It's a different right entirely. So it's a different provision. So why do you think we have that rule? Why do you think they have the rule that if you do not have the right to sell, you are in breach of a condition? Why do you think we have that rule? May not be total ownership. That's to protect people. So when yeah, to protect the buyer or the seller. It depends. It depends because that's what people have said that this rule is very problematic because it doesn't do a good job of protecting both of them at every point in time or at many points in time. It will be protecting one innocent party against another innocent party, especially when the rogue that sold the goods has disappeared. If that person has disappeared, then you have to protect one innocent person ahead of the or that one. So that's a challenge. is to make an attempt at protecting innocent contract buyers. So the rule is in place to provide redress when the seller does not have the right to sell. And a seller will not be in breach of this rule if at the time of the contract they do not have the right to sell, but they are able to get that right before the right to delete before delivery. So, and that's the way it is. I know you've heard about drop shipping. I think this section is ahead of its time. So with drop shipping, if I understand it correctly, you are able to sell something that is not actually yours. It's hinged on this section, right? So it is there to protect one of the innocent parties. And the court is often faced with the question of which innocent party should we protect now? Should it be the innocent seller, I mean the buyer, or the owner? So the lawyer is forced to choose between the two. And because that's the way that section is choosing between two innocent parties in most cases. It has been criticized that it doesn't protect any of them, and we don't know who will be protected until the cases happen. So you can say there's a criticism of that principle, and the leading case is Roland and Duval. You can briefly summarize the facts of that case. The buyer of a car sold it for profit to X, but that car was stolen before it was sold to the buyer. So the original owner of the vehicle sued X, and X claimed that he had paid price from B, and B also claimed his price from S. And it was argued in that case that S was in breach of Section 12, that indeed he did not have the right to sell. The court of appeal in that case allowed the buyer to recover his purchase price from S, but refused to make any deduction for the 4 months of use. So the first criticism is about that use, that collateral benefit that the buyer gets. So you use the car for a while, you've enjoyed some benefits, but when you're returning the car, you get all your money back. That's a very good deal, isn't it? So that's the first criticism. And the reason the court said that, yeah. So what I see your question there. What it means is that you cannot say you have accepted the goods. You know, with breach of section 13 and 14, satisfactory quality and description, you can say the buyer has kept the goods for a while, so they've accepted it. You know, the way it is, if you buy something that you do not like, what would you do? You would return it immediately or after a reasonable time. But if you've let the seller know in a way that you don't mind, I don't mind that you do not have the title, it's fine. So that will be deemed acceptance. You can look at section 49, section 47 sections. Can't remember the other ones now on acceptance. But what we're saying here is that when it's a breach of section 12, we say it's a fundamental, a condition, higher level than the other ones. So you cannot claim that the buyer has accepted that you do not have title. So they've waived their right to reject. Does that make sense, Kim? So this section is very, the courts are very strict when it comes to ownership, that you cannot say they've accepted. And how can you accept anyway that someone doesn't have the title to sell something to you? You're not getting what you're contracting for. So you cannot accept that because the title is defective. Does that make sense? So this condition, the right to sell, is the most serious of them all. So it is not acceptable to say, oh, the buyer has accepted. No, they can return at any point in the future, even if you've made it clear to them later that you do not have title. It's fundamental to that contract. There has to be that transfer of ownership. which is not the case. So I hope that that's clear. I see that you say yes, thank you. So going back, yeah. Yes, I'm just reading a question posted by Laming. That's a very good argument I should make, and that's the main argument about the total failure of consideration. You've just summarized what failure of consideration means, that you are not getting property because the title is defective. So you are creating a lot of problems for yourself, as such as dealing in stolen goods. So yeah, you see that in the world of luxury watches. Yeah, that's a very good point. So that's the whole argument on total failure of consideration. Does that help? So very good argument there, Kim. And that is why there's that exception. You can buy something that is of lesser quality, Section 14, that is not in line with the description, and say, yeah, you know what, I accept it. It's fine. But if you don't get title, you get nothing. So that's why acceptance cannot be claimed when it comes to Section 12. You can claim acceptance for the other sections, but you cannot do that for Section 12. So very good argument there. I'd like to see all these brilliant arguments in the assessment. I'd like to see that in the assessment. So going back to the question, you want to say this is on the basis that there's a total failure of consideration from S, from the seller, because the buyer had not received what he had contracted for. What he contracted for is the title to the car. I want to buy the car. I don't want to rent the car. I don't want to hire the car. So, like someone said earlier, being able to drive a car is ancillary to owning it. But you can still drive the car, use it if you don't own it. So that's total failure of consideration. So using that car for 4 months, that is not consideration in that contract, because the contract was not for the use of the car. It's for the purchase of the car, and you did not get what you contracted for. So going back to the authority, Roland and Deval, Atkin LJ in that case shows that the buyer does not lose the right to reject the contract through acceptance. So going back to the question you asked, Kim, the authority for acceptance not being relevant to Section 12 is Roland and Deval. So you can just say acceptance does not apply here because that's not what you contracted for. And this was the statement of Atkin LJ in Roland and Deval. So moving on with your discussion, you can say this result may seem justified. It could seem sensible because there was never a prospect of the buyer getting good title since the good was stolen. So if it was stolen, it's stolen. You could never get to good title to something that is stolen. So you can say that, yeah, that makes sense. You should be able to reject that and get your money back. But the rule has been criticized. Even the law reform proposed that the buyer should be able to reject, but should give credit for the use of the vehicle. And the question, when I say you need to engage with sources, you need to engage well in answering the question. You might want to ask, why should this section be treated differently by the courts to other breaches or to breaches of other conditions? And it goes back to the question asked by um, Kim. Why shouldn't you be able to claim acceptance? What is so special about Section 12? Can anyone answer? Can anyone tell me their thoughts in this or on this in the comment section? Why do you think Section 12 is being treated differently? So you can ask that question in the assessment if you're writing and say, what is so special? Why is this section treated more strictly by courts compared to sections 13 and 14, for instance? Why is it so important? What do you think? So while you're still putting your thoughts together, okay, I can tell lies without being penalized. Yeah. So it just shows that there's there is consequences for everything you do. So it's just to ensure that there's a bit of sanity in the business environment. Yeah. And I like what you've also put there, Lee. That title is everything when owning property. It's just like going to the market to buy a car and they've given you a steering wheel. That's different. Okay, yeah, I'm liking what I'm saying. Right to sell is fundamental to the contract, is the core aspect of the contract. Title is everything. And what law has written here, unlike other implied terms like satisfactory quality, ownership is the foundation. I like that you put foundation in bold. It is the foundation of any sale. If you cannot transfer ownership, the buyer gets nothing of value. I mean, people might argue that being able to use the goods for a while, that's valuable because you can put an amount on it. But the answer to that is in the contract of sale, value is interpreted in relation to being able to own. Sale means own. If they want to borrow, if they want to hire, they know to do that. So you can ask that question and go into this analysis. Yeah, by all means do that. And that's the question in Roland versus Deval, but this was also expanded in the Guido case. In Guido van der Gaard, the court clarified what they meant by total failure of consideration, stating that here, failure of performance of the key, essential, fundamental obligations to the main purpose of the contract, as opposed to merely incidental, or to borrow one of these words, collateral benefits. Collateral benefit or incidental. That's not what you've contracted for. And that's not what you're getting. You're not getting the essence, the totality of what you're buying. So in these scenarios, the main purpose of the contract has been the passing of property, not the use of the vehicle. So if what you're getting is not the passing of the property, is not the passing of property, but the use of vehicle, that is total failure of consideration. That is total failure of consideration. So where the seller subsequently acquires good title from the owner, then feeds the title to him. You know, why I said feeding the title, the higher purchaser buys. It can't happen when it's a rogue, but if it's a higher purchase, that can happen. And the higher purchaser pays off the balance and is able to pass good title up the chain. In that case, there is no claim for total failure of consideration because you're able to get what you've paid for. So you're asking if you can talk about the bona fide purchaser. Yes, if you're talking about higher purchase, because, and that's why I said that the main exception that applies to this Section 12 discussion is the higher purchase exception of Section 27. That's a key section that applies. So now I'm trying to rush through what we're doing just so you could go on break. Should I let you go now or should I finish with this question? Um, yeah, so I've got a question there. You're going to be provided with a statute book that has got all the sections you need to use. You have to ask Bessie about that, but she told me that there is a printed statute that you get all the sections you need for the exam. Yeah, good. So I think we're going to have a 15 minutes break. So I think we should just let me see where I've stopped. We've talked about this up until the issue of total failure of consideration, and we've talked about the case Van Giedo van der Gaard, and I think we should leave at 12:55. No, sorry, not my time here. Your time. What time is it in Hong Kong, please? Because that's what caused the confusion earlier. What time is it? 8:54. Good, thank you. So we're leaving at 8:54. Is it okay to ask you to be back by 9:10? Okay, 9:10. So we'll be finishing 1 hour afterwards. Okay. Thank you all. And once again, I'm sorry about the mix-up with the time earlier. And see you soon in 15 minutes. Take some break and stretch your legs. See you later. Yeah. So welcome back, everyone, from your break. Back, everyone, from your break. Can you all hear me? Please confirm in the yes. Okay, great. Yeah. Thank you for confirming. Now, there's a question from Wing. You want to know if I will repeat the sections 13 and 14 on B2C or B2B. So, like I said earlier, that's part of the things being tested. We want to be sure that you're able to distinguish between B2B and B2C contracts. From the fact, it's very clear, it's quite glaring. So, that's a decision you have to make yourself. I cannot comment on. I know you want me to comment so you could focus your attention on whether it's a B2B or B2C contract. But that's part of the thing being tested. So at this moment, I cannot comment on that. So I want us to continue from where we left off. I'll start sharing my screen again. So I think I was talking about feeding title up the chain. So when the hirer has paid up their balance and then they're able to pass on good title to the seller. So that's where we left off. That's what we're talking about. So hopefully you can see my screen. I mean, it's just a question, isn't it? Now, if that happens, then there's no claim for total failure of consideration because you're getting what you've contracted for. So at that point, the argument is you cannot claim for a breach of Section 12, but you may be able to claim for damages. You cannot claim for total failure of consideration, but you may be able to claim for damages. Moving on, you can also talk about the case of Butterworth uh, and Kingsway Motors, where the buyer bought a car on hire purchase, but before she completed the payment, she sold the car on to the buyer. And that buyer sold the car to the defendant's car dealer, who sold it to the claimant, Butterworth. 11 months later, after that sale, Butterworth discovered that the car was is subject to hire purchase, and he wrote to the car dealer saying, "I don't want the car anymore." And I think I said this earlier. That is a very good deal for for the customer, for the buyer. If you're able to use a car for free for 10 years, who wouldn't jump at that opportunity? So when he wrote that letter, the buyer was made aware of that development and he quickly paid up the hire purchase fee sum, and title was fed down the lane, the line to the dealer and to the claimant. And the court held that Butterworth had rejected the goods before good title passed to the dealer. So for that reason, he's able to claim total failure of consideration. So if you're answering a question on that, what you want to say is the key considerations will be when title passed, when the final payments were made, and when the goods were rejected by the seller. And it was held that Butterworth, yeah, he had rejected the goods before title passed to the dealer, and he was entitled to reclaim the purchase price, even though he used the car for 11 months. And what would you might want to reflect on this in answering the question and say that this is quite harsh. It is quite harsh that he's still able to reject after using the car for free for 11 months. And might also want to reflect on what Person J said in relation to what the results would be if that rejection had taken place after the title had been fed. But so if you're trying to reject after title had been fed, Pearson was of the view that there are doubts as to whether the claimant will be able to reject because he has got exactly what he contracted for. In New Zealand, it has been decided that if the seller acquires good title before rejection, then it will be too late to recover the price. That was the decision of the court in Patton versus Thomas Mottos. And you might want to think about this not affecting the fact that at the time of the sale there was no right. So you still may be able to sue for damages for not being able to pass good title. But the question again, the next question is, what if the buyer acquires good title, not because title has been fed, but because of other exceptions to the NEMODAT? So this is where the NEMODAT comes in. But this is not an opportunity to go into detail regarding the NEMODAT. You're just citing it in relation to what happens. What happens when a buyer gets title using one of the exceptions. And in this case, what happens is that it's not entirely clear. It's not entirely clear. For example, in Niblet's case, it was suggested that even though the seller did not have good title, title will pass because of the NEMO exception. However, Good disagree with that view because he said in that situation, a seller should not be obliged to take title because that would be a very complicated title you've got. So just imagine you're selling something that you know there has been some issue in relation to the title. People don't want to buy that, and the people that buy it, they want to pay less for it. So that's very problematic. That was a view of Good. Yeah, he says it would be a complicated title, and that seller or buyer might experience difficulty in selling the goods through no fault of his own. So if you're engaging, you might think, yeah, he gets good title today, but what about in the future when someone wants to buy that thing and they're asking about, or they discover that there was that issue with the title in the past? They may not be they may not be so motivated to actually buy that goods. And as a point of caveat, remember that Butterworth was decided before the 1964 Act was introduced. And in that case, the disposition is to, I mean, it provides that Section 27, that if it's a disposition to a private seller, and the person has bought in good faith without notice of the defect in title, they are able to get good title. But remember that this exception does not apply to a dealer, a car dealer. So it could only pass good title to private parties, not car dealers. And they have to buy in good faith. So if, say, a buyer buys at a knockdown price, then we might question whether that was buying in good faith. But that's not the issue at hand. In this case, yeah. But you can raise that just to show that you understand what the law is. So we know that Butterworth would have been decided differently if it was decided after the passing of the Hire Purchase Act. But that wasn't the case, so it was decided the way it was decided. So if Butterworth was the first purchaser in good faith without notice under the Act, he would acquire good title. But the person that sold on to him would still have been in breach of Section 12. And the question is, could you, in those circumstances, still reject the goods? So, say you've purchased the goods and you're a private buyer, you've purchased from someone that got it through hire purchase, you're a private purchaser, and you've discovered that the person that sold the goods to you does not own it. Can you still reject? So in Baba and NWS, a hirer, that was what happened in Baba and NWS. A hirer sold a car subject to a hire purchase agreement. And by virtue of Section 27, the final purchaser could have acquired good title, even though this dealer that sold to them did not have good title. But remember, Section 27 says you can get good title if you're a private purchaser because you do not understand the intricacies of how hire purchase works. And you may think because the seller has got possession of the vehicle, they own it and you are protected. So the question is, will you still be able to reject if you've got good title? So in that case, there is no total failure of consideration. You've actually got what you contracted for, even though the seller breached the rule. And the Court of Appeal in Barber said, the buyer is still allowed to reject the goods. They said he's still allowed to reject the goods. And in this case, you're beginning to wonder, is this really about total failure of consideration, or are the courts taking this interpretation to an extreme? So in the Act, it is made clear in Section 27(6) that the provisions should not benefit the employees of the motor trade. So because the buyer is not an employee of the motor trade, he was able to reject. The final buyer, again, could claim back his purchase price because since he has rejected, total failure of consideration, he needs to get the money back. And some people have argued that this decision could be restricted to hire purchase agreements. So what they're trying to say is the court appears to be drawing the distinction between purchases where the seller does not have a right to sell at the time of sale, but title is fed before the buyer rejects. So he did not have the right to sell at the time of sale, and title is passed before yeah, before he rejects the title. There's a distinction between that, and there's also a distinction between sale, where title is fed before the buyer rejects. That's different from when the seller does not have the right to sell, but its buyer will acquire good title by virtue of hire purchase or NEMO that exceptions, all the other exceptions. And the court is also saying where the seller does not have the title, but they acquire the title afterwards. So this is a very confusing thing the court has done. So again, I'll retake that. By the decision of the court in Baba and NWS, the court appears to be drawing a distinction between purchases where the seller does not have a right to sell at the time of sale, but title is fed before the buyer rejects. So if that's the case, you say the buyer gets good title, title has been fed, you get good title. But that has been distinguished from when the seller does not have the right to sell, but the buyer will acquire good title by operation of a NEMO that exception. That's the second situation the court is drawing a distinction with. And also, the final one is where the seller does not have title, but the buyer acquires title through the operation of Section 27 of the Hire Purchase Act. So it is a distinction that cannot be supported in principle. It's either you're arguing that there is total failure of consideration or there is no total failure of consideration. There are no two ways about it. So where the NEMO that exception could confer good title, one could ask, we could ask that how can this be said to be total failure of consideration? And I think I've raised that point earlier, that if you can get good title through one NEMO that exception, you really cannot say that's total failure of consideration. That's not total failure. You get title that you've contracted for. So the buyer can obtain precisely that thing he had contracted to receive, which is good title in the goods in the vehicle. And it would seem to be very harsh decision and outcome for the seller. So now the buyer has used that car for 11 months or 2 years or for longer, and you're saying they're able to reject even though they got good title. On the other hand, while the buyer at first sight seems not to have suffered any loss, it may become problematic. It may become a problem when he wants to sell it on. So we're trying to balance this size. We're trying to not give too much burden on the seller and not too much benefit on the buyer. But at the same time, what if the seller wants to sell on? It may be difficult if the new buyer discovers that there has been a form of dispute. And I think what was said in relation to the expensive watch market, what you said is like it's very fundamental to have that right to sell. So if there is any form of dispute over the title of goods in the history, the buyer who seeks to sell them on will surely find it difficult to find someone that would buy from him. And even if they're buying from him, they may be buying for a knockdown price. So that is a very nuance point that should be taken into consideration. And it may be argued that that's why the Law Commission thought it best to keep the law as is, because why should we punish the buyer for the mistake of the seller or someone up the chain? So this issue, the issue of that balance, might lead us to question whether the approach suggested by Person J in Butterworth and Kingsway, that you would lose the right to reject once the title is fed, can be supported in the interest of consistency. So do we think to ensure that everyone follow the same rule, everything is consistent in the market, can we argue that, yeah, you will lose the right to reject if title is fed? And in that case, the approach suggested by the Law Commission may be the fairest way. That is, they suggested that to allow rejection whilst the buyer gives credit for any benefit he may have had. So that was one of the approaches they talked about, even though that didn't become the law. So what this would mean is that the buyer will still be able to reject the contract even though they have good title. But when they do that, they have to pay for the use. Does that make sense? So as a buyer, if you know you've got good title and you'll be made to pay for the use after a while, you may be reluctant. You will think twice about changing your mind about goods. You may think twice about that. So there was an opportunity for reform. Remember, we're criticizing this rule. The first criticism is that is that really a total failure of consideration? Is the rule too strict? Who does it protect? And then that's three criticisms really. And the next one is why do we have different outcomes for different situations? So there's a different outcome if it's a higher purchase, a sale from a higher purchase contract, or if the title has been fed, or if any of the other. So it's inconsistent and it's confusing. There's no certainty in that law. So there was an opportunity for reform, like I said, for to answer all this question, where the Consumer Rights Act, Section 17(1) implies a parallel term to Section 12(1) into a contract between the trader and the consumer. So it defines who a consumer is and it defines who a trader is, but the statute provides a remedy that the consumer can reject the goods for breach of implied term, and but you cannot there cannot be acceptance if there is a breach of title. If you don't have title, you cannot say there's an acceptance. So normally for a consumer, do you have that 30-day early right to reject? And you can ask for a right to request a repair or replacement, or a final right to reject or price reduction. But looking at the issue of ownership, the issue of right to sell, it does not apply to the right to sell. So there are no limitations on the right to reject for not having the right to sell. So this means that a consumer buyer has the right to reject under that act, and it is not time limited. So you can reject at any time. So that means that this act, the Consumer Rights Act, gives that elevated protection to buyer compared to the Sale of Goods Act. And that's it serving its purpose, because the Consumer Rights Act is to create that higher level of protection for consumers. Remember what we said earlier that if you're negotiating with your Taobao, they have their terms that you have to accept. You cannot negotiate with them. So that's why it makes sense that as a consumer, there are no limitations to the time limit. There's no time limit for when you can reject. So this is something you can point out in the assessment. So if a consumer exercises the final right to reject on one of the implied terms for fitness of purpose, quality, compliance, then the trader has the right to reject, to reduce the refund to show that the consumer has used them. But when it comes to right to sell, no price reduction is going to be relevant because Section 24(8) of the CRA says that the limitations in sections 22 and 24 do not apply to the breach of the right to sell. So again, for consumer contracts, there will be no reduction akin to the effect of reduction for use. So it's the same level of protection, if you like, compared to Roland and Deval. So the right to sell, again, you keep referring to that in answering this question. You keep saying the right to sell is based on a total failure of consideration. And if you cannot give consideration for the goods, the contract is non-existent, basically. It is total failure of consideration. But what we see here is that what is not clear, what is unclear, we know what's clear. You have more rights as a consumer. There's no time limit to when you can reject. What is not clear is that under Section 17 sub 1, the statutory remedy for implied term is affected by feeding of title. So what happens if you obtain title from NEMODAT exceptions? Or what happens if you obtain title because the hirer has paid up all that? We do not know that. The Act does not specify. The Consumer Rights Act does not specify. So again, that is unclear, as is the case with the Sale of Goods Act as well. And it is arguable that the cases under SGA will also apply to the right to reject under CRA because they're not very different when it comes to title. There is no acceptance on that SGA, no acceptance on that CRA, no limit to time where you can reject. You don't have to pay for collateral benefits. So the cases can also apply. So that's the justification for applying the other cases we've talked about earlier. So as such, it will be in the interest of consumers of the consumer to delay the rejecting of the goods onto the party. So you're using the car, you're very sure that the car is not the property of is not the person that sold it to you does not own it. You're not going to tell anyone as a consumer, would you? You're not, because you can continue to use it. And then when it gets to a point that the true owner comes to you and say, "Oh, that's my car," that's when you say, "Yeah, gotcha. I'll reject now." So this is also a problem, isn't it? So the introduction of the provisions under the CRA was a really good opportunity. And you will do well to mention that in your answer, that it's a really good opportunity to change the direction of the remedies for the breach of implied term to sell. But potentially, the new provisions are even more favorable to consumers than the rules that have been criticized under the SGA. So you see, now, I mean, because it doesn't specify the time limit to reject, it means that it's even more expansive because it has talked about the right to reject for, say, satisfactory quality or fitness or purpose, but it leaves it open for the right to sell. And the argument is, should it have specified that? And some people might want to say, if it says that a consumer needs to reject within, say, 1 year, that would mean the consumer has less protection compared to your a business to business contract. So why should that be the case when the CRA is there to give that elevated protection to consumers? So it's a very difficult thing to get our heads around. But we know at this point that the CRA does not put limit to the time, does not say consumers should pay for the use for that period and does not say that when title is fair, they can no longer reject. So again, really good for the consumer, but bad for the innocent owner. Now, when we're looking at the slides, I said that you should not focus on section 12(1) alone. You should also talk about section 12(2), which is the case of Morgan that I talked about, the collateral, the implied warranty. So the second part of section 12 is section 12(2), that there are also implied warranties that the goods are free and will remain free of encumbrances not known to the buyer. And we see that there's a remedy, which is, you can claim for damages. It's not a condition, it's just um, it's a warranty. You cannot reject based on that, but you got something to reject for anyway, section 12(1). So section 55 of the Act also provides that where a right, duty, or liability arises under a contract of sale by implication of law, you can negative it or you can vary it by express agreement. But the availability of this has been curtailed by the Unfair Contract Terms Act, which provides that you cannot exclude liability for breach of 12(1). So you're always liable for Section 12(1). You're not escaping it. Remember what I said about unequal bargaining power. The UNCTAD is trying to protect the party with limited bargaining power, not just consumers, smaller businesses. So you cannot contract out of Section 12(1), but you may be able to contract out of the other sections or this warranty. So this means that the act protects the buyer at the expense of the buyer who cannot be certain about the title of the goods, and it seems to make serious inroads into the principle of freedom of contract. And there are similar provisions in the CRA. So why shouldn't people be able to say, yeah, well, it doesn't matter if I have title or not. You should get ownership. You should the sale of goods should take place. Again, it goes back to the unequal bargaining power. You think if the big companies can get away with selling something to you, getting your money and not giving you goods, you think they won't? They will. And that's why the law, through the OCTA, the CRA, gives that elevated protection to consumers or small businesses. I mean, people could argue that, oh, there's freedom of contract, but really, is there freedom of contract if there is that powerful? It's just like David and Goliath. David is very small, Goliath very huge. What's freedom of contract with Goliath? You really can't make sense of that. So that's the sense in that if someone argues that it's it derogates from the concept of freedom of contract, not really. So excuse me. So there can be doubts about a person's title to goods. And in this case, Dobson mentioned that a person who has found goods but wishes to sell them on, drop shipping, the goods belong to the original owner, right? But under section 12(3), a person will not be liable for the breach of section 12(1) if he has disclosed his limited in title. So if you're saying, I'm doing drop shipping, I can get these goods to you. I don't own it now. You're able to contract out of the provisions of Section 12(2), etc. Because the person is aware, they're free to enter into the contract or not. So while this is a sensible provisions, it means that there's a wide gap in the principle that you cannot exclude liability for Section 12, but you can exclude for yeah, you have limited title. And this is an effective block on claims where limited title has been disclosed. And it means that the party can prevent claims when they have disclosed their limited title. And by talking about the other sections, you've covered, time permitting, everything. So you don't have to go into so much detail, but you need to discuss these cases, the differences of perspectives in relation to hire purchase, in relation to feeding of title, in relation to the Nemuda exceptions. And you go back. This is something we keep repeating in here. Total failure of consideration. Go back to that when you're discussing it and say the basis of a claim for Section 12 is total failure of consideration. But overall, it will seem that there are fine distinctions. There are very subtle distinctions in law where a party will be able to reject goods for breach of Section 12. So there are harsh consequences where a party has allowed someone else to use their goods for a while, and then that third party is able to return the goods to them and get the full money. And remember what we said about depreciation. Goods, cars depreciate. So if someone else has used the car for 11 months, they're getting the full purchase price, but they've used it. So that means the innocent buyer is at a better position compared to the seller. So the law reform, you can argue that they lost the opportunity to ensure that consistency is found in the treatment. Yeah, so what if the good appreciates in value? That's a very good question. Well, about what do the other people think? What do you think if it appreciates in value? What do you think the position? No, yeah, so Lee is saying cars appreciate in value. Do you agree? Some of them, yeah, the antique ones, yeah. But generally, cars depreciate in value. It's just the exceptional ones. Yeah, you're right. So if the car appreciates in value, if you've been able to get good title through the Nemo that exceptions, through the hire purchase exception, through feeding of title, you don't have to return it. And even if the owner sues you, they cannot get the car back. Do you understand? So again, this is something you might want to raise and say, what if the car appreciates in value? It's not about total failure of consideration, is it? If the buyer is allowed to keep the car, because now it benefits them, not the seller. But if it's a car that depreciates in value, yeah, when you talk about unjust enrichment, there has to be that element of fraud, I think. But in this case, that's not what happened. The fraud is not coming from the buyer. It's coming from someone else. So they're still able. So that's one of the arguments. That's one of the criticisms that you've been able to enrich yourself. It's not fair on the seller. I mean on the owner. But if you get the car through exceptions, yeah, unjustly, yeah. If you get the if you get the car through one of the exceptions, you get it. You don't have to return it. And again, that is the injustice in the application of Section 12, that you're able to keep the car when it suits you, or you're able to reject it when it suits you. Does that make sense, Lee? Do you understand? So that's part of the criticism. So if the buyer gets good title, he can decide to keep the car. So, yeah, to wrap it up, you can talk about the inconsistency. Just summarize. Consistency should be found in the treatment of breach and the proposal for the reform to ensure that the buyer is not overcompensated. But we don't know what that is. We don't know what's going to happen in the future. So we have to wait for clarifications to see whether the provisions of the CRA offered even greater protection for the seller compared to the buyer. So, yeah, I think that's it for that question. The next one is a problem question that is in relation to Jimmy. Let me remove the keyboard. Yeah. So now I'll give us a moment to read this. So if you're answering a question on this in the assessment, how would you start? What's the first thing you need to do? What do you need to do first? Good. Type of contract, very good. Good. Yeah. But that is a consumer rights contract. So looking at this, so it's a business to business transaction, of course. So the if it's a business to business transaction, what applies? SOGA, good, good one. The type of contract. One thing students don't, many students do it, but not all of you, all of the students. You need to identify the main issue. So the main issue is, what is the main issue? You need to identify the issue before proceeding. Like this is a question, but you need to summarize it to something you will be answering. So in your own words, you need to identify what the main issue is. What is that? Looking at this question. Good. Whether Jimmy has the right to sell. So the consideration here, good. Yes, yes, very good. So the question requires the consideration of whether and when title passes under the relevant contracts. So you want to know as title passed. You can say that in any way. What we just want to see is you raising the question at the onset. So you said the main issue is this, whether Jimmy has the right to sell, what are the respective rights of the parties under the under the contract. Very good. So yes, as title passed under the relevant contract and what are the respective rights of the parties. So now let's look at it. Starting from Jimmy, who is the owner of the van? Who is the owner? From the starting point, from point A, DF, Dodgy Finance. Yes, they are the owner. And Jimmy, good. Jimmy is the hirer. So he doesn't own the car. And by virtue of that, he's unable to pass title in the vehicle. But we know the law is not straightforward, is it? There are exceptions to the rule. So under the hire purchase agreement, Dodgy will acquire title from A and then hire the van to Jimmy. And upon completion of all the hire purchase payments, an optional purchase fee will be paid by Jimmy, and then title will pass to him. But Jimmy did not allow that to happen. And like you said, he's not a consumer, so he doesn't get the extra protection of the CRA. Right. So it's governed by the H Hire Purchase Act. And yeah, so if the purchase was after, yeah, or if then it doesn't matter since the uh, SGA applied to B2B and B2C contract. So this is not a sale of goods. You see where the definition comes in here. It's not a sale of goods contract looking at Helby versus Matthews, but we'll be concerned with the rights under CRA, under SGA, sorry, because there are a number of other transactions that take place that involved sale. So the SGA is relevant. So we start from the general principle. What is the general principle? What is the relevant general principle here? Guys, stick with me. Good, Kim. You cannot acquire a better title than the seller has. So that is the name of that principle, section 21. You cannot acquire a better title than the seller has. However, like every good thing in life, there are a number of exceptions to this rule. And you might also want to mention that there is also an implied condition that in a B2B contract, the seller has the right to sell the goods. And that is section 12 of the SGA. So you're applying section 21 and section 12 because they go hand in hand, but you don't want to focus too much on the NEMO-DAT exceptions. So what is the case we're starting with? You've talked about the sections. You get points for that. You need to talk about cases too. So what is a case? What case would you start with? Good. LB versus Matthews, Niblet, good. But there's one that we've been talking about, like that's a starting point. Not these two. Roland, you want to start with Roland and summarize a car was stolen and it was used by 2 months, used by the buyer for 2 months, and then they had the price back because so yeah, you go into Roland and Deval. That's the starting point for any discussion on section 12. You don't have title, you cannot give title you do not have. And you want to say in that case, the court said there was a breach of section 12, which was a condition going by section 55, is it? Saying it's a condition. So the defendant did not have the right to sell the cars and he sold it. That's a breach of section 12. And in this case, the implication is you are able to reject. You're able to repudiate and get your money back because there is what? Per Atkin LJ, there is total failure of consideration. It is immaterial that you've been able to use the car for 2 months. You can even use it for 2 years for all we care. But because that's not what the contract was for, it was to buy the car. You did not get title. That's it. So there's total failure of consideration. So it doesn't matter if you use the car. There's total failure. So what it means in essence is that you as the buyer have been able to use the car for free for 2 months. Tough luck for the owner, but it's not your fault. So you had the car for 2 months, yeah. And you might also want to mention on the principle of acceptance. What about the principle of acceptance? What is the rule about acceptance in relation to section 12? Very good. Very good. Kim. Yes, very good, Wong. Yeah, very good, Lee. Acceptance does not apply. It doesn't apply under this SGA. It doesn't apply under CRA because the right to sell is a condition that is greater than all the other conditions. And you might want to raise a question that why is it so different? But you're still describing the law here before you start engaging with it. So the principle of acceptance has no relevance to such a claim. It is not open to the defendant to argue that the claimant had accepted the goods and could no longer reject them. No, sorry, no, defendant. You cannot claim acceptance. The other case you want to touch on could be Guido van der Gaard, where the court confirmed that total failure of consideration was concerned with a failure to perform the obligations, which was the main purpose of the agreement, as opposed to incidental or collateral ones. So yes, if you buy a car, you're able to drive it, you're able to use it, you're able to take pictures with it, etc. But that's not all there is to it. You can also take a picture with other people's cars. You can drive a car on hire purchase because driving the car is the crux of the hire purchase agreement. But when it comes to buying, owning the car is the crux of the agreement. And if you don't get that, there is total failure of consideration. So that was a decision in Guido van der Gaard. Now, you want to move on to talk about where else this principle was considered. Um, Again, in Butterworth and Kingsway, Barber, those are all the cases you want to talk about. But let's start with Butterworth and Kingsway. A car that was subject to a hire purchase agreement was sold before the hire purchase agreement has been made. So you can see that the Butterworth case, and this one is in pari material. They're very similar. So you can point that out and say this case is very similar to Butterworth, where a car subject to a hire purchase agreement was sold before payment under the hire purchase agreement, but before the ownership was transferred. So the seller had no title in that case. And 1 week later, 1 week after, uh, I mean, the buyer discovered, right, and rejected the car. And 1 week after that, the IRA paid off, and title was passed to the seller, I mean, to the hirer by then. But that was after he rejected the that was after I rejected the goods. So it was too late in the day to be paying off the hire purchase. And the court decided that the claimant had rejected the car before title was fed up the chain. So the defendant had been in breach of Section 12 at the time he sold the car to the claimant. And in that case, it meant that he was entitled to reject the car, and the court applied Rowland and Deval. I don't know how you're discussing Section 12 without talking about Rowland versus Deval. I want to see it in your essay. I want to see it in your answer. It's very key. Write that somewhere, guys. Roland versus Deval has to be in your answer because it's a primary case, it's a core case that discuss this. Other cases expand or explain what was said in Roland. So you will do well to apply the case. So the court in the case I just talked about applied Roland and Deval and held that there was no right to be set off. They don't have to pay anything for the use of the car by the claimants. They don't have to pay anything. Even though they've used it, they've enjoyed the car. And you might want to reflect on um, the implication of this. It's a very harsh result because it means that the claimant has enjoyed free use of the car. And 1 week later, they would have acquired good title. So that makes it even more difficult. So if when they rejected the car or for a reasonable period after then, they're unable to get good title, yeah, that's not a very um yeah, that's immaterial. But in this case, it was just 1 week after, and it seems like a harsh decision, right? Because the claimants in that case had used the vehicle for 12 months, for 11 months, for free, for free. That was painful, wasn't it? But just 1 week later, they would have acquired good title, but they still were able to reject. And the court in that case left open the question of what would happen if the claimants had rejected the car after title had been fed. But remember what I said earlier, that Pearson J said he would likely not be able to reject because he got what he contracted for. And again, that view can be criticized. You getting the car for now doesn't mean you won't face trouble down the line when you want to sell it. But exactly, we're saying you got what you contracted for, so yeah, everything is good, everything is okay. So he made that suggestion, but that decision was not concluded on, because you know the way cases are decided. If you if something is a fact in issue, courts are able to pronounce on that. They're able to make judgments on that. But in this case, this is something not before the court. So whatever they say is obita, is not ratio decidendi, is not binding on subsequent courts. But there are some other issues with other points on that, which we're not getting into here. Now, having decided that um, you cannot get good title, you're able to reject if a higher purchase, we now have to decide what are the conditions upon which Jimmy may be able to get good title. So we need to determine when Jimmy paid off the outstanding hire purchase agreement. When did it pay? And that is a crucial point for us to determine who owns the van. If the payment was made before the van was rejected, it is likely that title would pass up and he would get what he contracted for. And the argument is the court might not allow him to reject the car for breach of Section 12, even though it was technically breached at the time of sale. At the time of rejection, he got title. So what is he rejecting? So that's the first point. But if I mean, in this case, we would say there's no total failure of consideration because he got what he wanted, even though at the time of sale he didn't. But there's also a further aspect of that question, which is over if the buyer had acquired the car, the van, under the hire purchase agreement. Remember, Section 27 provides that if you're a private purchaser, you can get good title. So, what does that mean? The section provides that Section 27, good title to a motor vehicle that is subject to a hire purchase agreement can pass to a buyer, but there are some conditions. There are criteria that have to be met. The first one is it has to be a motor vehicle. Yeah, good. Thank you for that. Private purchaser. It has to be a motor vehicle. It has to be a private purchaser, and it has to have. I think there's a second condition. It has to buy it in what? Good faith. I was expecting you to type that in. So it has to be a motor vehicle. Private purchaser must purchase in good faith. So if he's aware that there's something dodgy going on, it will not get good title. But under Section 27(3), where the vehicle is bought by a dealer, it will not get good title. You can go into the definition. In this case, Kevin is a delivery driver. So his business is not related to buying and selling motor vehicles. So that's a very key distinction to make because we can make a mistake of, oh, it's a business to business. This is a different thing entirely. Business to business to one side. But here, Kevin is into the delivery business, is not into the business of selling cars or all that. So he's a private purchaser and he's able to, we can say he had bought in good faith because there's nothing sneaky going on with the vehicle. So we can just say he bought in good faith. Uh, although, can we say he bought in good faith here? Is there any point in the question that could point to the fact that he didn't buy in good faith? Guys, do you think he bought in good faith? No? Good. I like that you're picking up the subtle, the unclear point, knock down price. He bought the vehicle at a knock down price. Sharp eye there, Lee. We're told he sold to him for a knockdown price, and what does that mean? It might raise a question as to whether he actually bought it in good faith or not. As a reasonable person would think, why am I buying a car for, let's see, how much did he buy it for? Yeah, dodgy. So, yeah, yes, he's a private purchaser. Even though, yes, you're right, Kim. Yeah, very good. Thank you very much for that case, Wong. Yeah. Kim, does that address your question? Because the definition of private purchaser is someone that is not dealing in cars and is dealing in food delivery. Does that make sense, Kim? Is dealing in food delivery, right? Yeah, I'm trying to see it again. In his building firm, yeah. Okay, so I'm interpreting another question. Okay, yeah, Kevin. Yeah, a local delivery. So he's doing delivery. So it's not a car. You would argue that he's not a private purchaser because it's for use of his business. Good argument. Can we have a look at what Section 27 says? Can we check that? Very good point. But let's look at the law ourselves, Section 27 HPA. Have you seen it? Have you seen the definition, Lee? Okay, good. Let's look at Section 27 together. Section 29 defines a private purchaser. Section 29, are we there? Section 29. So I'm going to copy, can you see it? Reading it well, he is not a private purchaser, right? Vehicle trade business. Because I wanted to copy it there. I'll copy it in the chat. So a private purchaser is someone that is not a car dealer. Does that make sense? Does it make sense to you, Lee? Yes. So a private purchaser is someone that is not a car dealer. And the reason for that section is to safeguard people that are not in the business of car dealing. Does that make sense? Let me go back to my question. So can you see the question again? Okay, good. Yeah. Can we continue now? Have we cleared up that confusion? So it's a very good distinction to make. Just because it's a business to business does not mean the person buying is a private purchaser. Yeah. Okay. Let's proceed because I think we have to wrap up by 20 for your time 10:25. Is that right? Is it 10:25 that we have to finish or 15? Trying to look at my document here. Let's see. Uh 12:10. Yeah, I think it's 25, right? Okay. So, because it's a private purchaser, is able to get that. But there's a challenge with him being an innocent, but he's not buying it in good faith. He bought it at a knockdown price. Kevin bought it at a knockdown price. Yeah. But in Baba and NWS, a buyer of a car that was subject to a higher outstanding HP was still able to reject the car, and he could have claimed that he could have claimed good title by operation of one of the Nemo Data exceptions, Section 27 of HBA. In this case, the dealer, do you think the dealer would get good title? There's a dealer there, isn't there? Did we have any dealer? Do we have any dealer here paying off delivery driver, selling it to the gardener? So there's no dealer, right? Yeah. So in this case, Kevin would get good title if he is able to prove that he bought in good faith. But there's that tainted part of it because he bought at a knockdown price. Um, the intermediate dealer in Baba's case did not have good title, but he was still able to pass on good title to private purchasers. And the reasoning behind this decision is that the HPA specifically relates says that Section 27 must should not benefit a person in the motor trade. So a literal interpretation, the private buyer was not to be forced to take the car from a motor trader. So it was open to the private buyer to reject. So for the fact that you're able to get good title doesn't mean you have to keep it. You can still reject. So that's the argument. But what is not clear, I mean, with this decision, it leaves us in a position that where a buyer would appear to be able to reject goods, even though it got to title. So if you get good title, you're still able to reject because there's been a breach, as in there. But what is not clear is whether such an approach would be extended to where you acquire good title under other exceptions. In this case, Kevin sold the van on to Alex. So if Kevin was deemed to be a private buyer who bought in good faith, we're not sure if he bought in good faith because of the price, but if he was, you might say that you make alternative fact scenario when you're answering questions. You can say, in this case, it's not clear if he bought in good faith, but if it was decided to have bought in good faith, then he will be able to pass good title to Alex, and it would not be open to Alex to reject the van, as Kevin would not have been in breach of Section 12. So he would have got a good title if he had bought in good faith and could pass that on. And if he's able to pass that on to Alex, Alex has got no leg to stand on. He cannot claim that I didn't get good title because Kevin got good title and he's able to pass that to you under the NEMO Section 27 exception. So this will also be the case if Jimmy, the first buyer, pays off the outstanding HP before Alex rejects the van. So if good title is fed down the line, they all, Alex, Kevin, all get good title, and there's nothing to reject. And this will be following Butterworth's Kingsway mottos. And in those circumstances, Alex would acquire good title, and the finance company could not pursue him for any debt. But if Kevin was deemed not to have purchased in good faith, so you're looking at alternative fact scenario, you're thinking if he got good title, if he doesn't get good title, do you get? So you're trying to cover all angles, and that's how really good students do. You present alternative facts arguments. If he got good title, this is what the situation is going to be. If he doesn't get good title, because he didn't buy in good faith, he bought because of a knockdown price. Look, using the authority you cited there earlier, then this is what happens. So in this case, if Kevin was not deemed to be let's start with if Kevin was not deemed to have purchased in good faith, and if Jimmy does not pay off the hire purchase agreement before Alex rejects the van, following Barbara's case, Alex would be the first private purchaser. And even though it would be possible for him to acquire a good title, it doesn't have to do that. He could reject the car and recover his own purchase price from Kevin. And that means that he would have used the car for free for any period in his possession. And the same approach would be open to Kevin. He might pursue any claim against B as long as he rejects before good title is fed when Jimmy pays the balance. So, in summary, the outcome of this case will depend on two key factors. The first one is when Jimmy pays off the balance of the hire purchase and when Alex rejects. So, if Jimmy pays off before Alex rejects, Alex cannot reject. Or if Alex rejects before Jimmy pays off, then he's able to reject and get all the full refund. So that's the first variable. That's the first factor. The second factor is, did Kevin buy in good faith? Did he buy in good faith? He bought at a low price. So if he didn't buy in good faith, he can't pass good title, can he? In any event, it doesn't seem like do, dodgy finance can pursue Alex if he bought in good faith and wishes to retain the vehicle. So I think it is this point that is very problematic where someone can decide. The buyer is up to the buyer to decide if we got the exception, to decide to reject if it favors him or reject him if it doesn't favor him. If you got the time in the assessment, you can also add some points to talk about the law reform, about how this has been criticized. But remember, that's not the focus of this question. So now going to talk about what this is in the assessment, section 12 is a problem question. Section 12 is a problem question. So you might want to revisit, if you have the time to watch this video over again, you might want to revisit the last answer we've just married. Also, I said it's not three factors, it's two. And I know it sounds like three, so I'll revisit them. The first one is it depends on, now go back to it. It depends on two things. The outcome of the case depends on two things. The first one is when Jimmy pays off. So when did he pay off? And when did Alex reject? So that is one. Both of those are one. Let me turn on my camera. So both of those are one. When Jimmy pays up and when Alex rejects. So if Jimmy pays up before Alex rejects, that means title has been fed down the line, right? And that would mean Alex gets the title because ownership, Jimmy gets ownership before Alex rejects, right? So that's the first point, the timing of rejection and the timing of payment. And the second issue is, did he buy in good faith? Did Kevin buy in good faith? If he did not buy in good faith, he cannot benefit from Section 27 of the HBA. And what that means is that he cannot give title to the next person before it gets to Alex. So does that explain the point to you, Kim? So it's two. But the first one looks like two things, but it's really about the timing. When was it paid off and when was it rejected? If rejection comes before paying off, it is valid. If paying off comes before rejection, that means it got good title and cannot reject. It may be able to sue for warranty, but it may not be able to reject. Now I said, yeah, we have like 7 more minutes to go. Yeah, I don't want to hold you for longer than necessary. So have you got any questions? I've said in the assessment, section 12 is a problem question. In the receipt, section 12 is an essay question. Does that make sense? In the main assessment, section 12 is a problem question, just like this number two. Facts differ, of course, but it's all the cases. It's test your ability, how well you understand what the questions are. And like I said, when you're answering a question on section 12, don't go into too much detail. Read the exceptions of Nemo-Dat principle. You're just talking about Nemo-Dat principle because ownership may be touched on anyway, but don't go into too much detail. The element of Nemo-Dat you want to discuss under section 12 is just the HBA exception because the courts are pronounced on that in Barber, in Buttersworth cases. So that's where it's relevant. So don't go into You're asking what questions are essay questions in the assessment. Nemo is essay question. I didn't write all of it down. I'll tell you as time goes on, as we're discussing the questions. And at the end of the session, I'll repeat what it is. But I know for sure that Nemo that we're still going to talk about that is an essay question. Uh, Section 12 is a problem question. So I'm going to update you on that law, Chi, as time goes on. Right. So you have 5 more minutes. Um, is there anything you're confused about? Is there anything regarding this topic? For tomorrow, when Thursday, Friday, Monday, there's going to be an overlap in what we discussed. So we're going to be covering more than one topic in a day. But we'll see how it goes as we progress because we have 5 more topics and 4 more days. But the plan really for today is just to cover what we've covered. Is we've done well within time, even though I didn't come on. Yeah. So, any questions? Is there anything you're confused about? Is there anything you'd like to know more about? Before we've got 4 more minutes, so I'll stay on here. If you don't have questions, you're welcome to leave. Um, I'm trying to see if there's anything I wanted to say. When yeah. So I'll be waiting. Which okay, no further questions. So I think our daily schedule we'll be having the first 90 minutes and then go for a 15-minute break. I know we didn't stick to that today, but yeah, and I also wanted to tell you that please always remind me to record when we start. So in case I forget, please remind me uh, to record for your own purpose. Yeah. And like I said, I've told you the things you need to do to have a high score. You need to talk about the difficult aspects of the law. Not just you touch on the straightforward aspect, but you also talk about the difficult aspect of the law. And I think in this case, in the scenario we just looked at, the difficult aspect is the different rules are applied depending on what exception, what rule you're following. So it's a different rule for if you're feeding title if title has been fed under hire purchase agreement, it's a different rule for if title has been fed, and it's a different rule for other Nemudat exceptions. So that's a problematic aspect that you would do well to, yeah. Ooh, tomorrow we're going to start on time at 7:10 Hong Kong time and 11:10 UK time. My understanding before today was because last year that was what we did. It was at 12 UK time, but this year it's 11 UK time. So yes, we're going to start at 7:10 Hong Kong time tomorrow, which is 11:10 UK time. So yeah. Okay. Okay. So that's a very good question about the open book exam. For the exams, it's not an open book exam because you'll be writing from memory. And I want to assure you that we have this at the back of our minds when we're marking your scripts. We know you're writing under that condition and you do not have your books before you. So we're able to give you credit when if you don't have to cite the full name of the case because we know it may be difficult to cram all of that. So if you cite the key name, so like Baba versus NWS, you may not remember NWS. You might say Baba or you might say NWS. In the case of NWS, you still get the full points. So it's a closed book exam, but you are able to access the statutes. And what I would advise students to do, what I would advise you to do is not to restate the provision of the statute because we're looking at your knowledge of the law. And what knowledge of the law are you demonstrating by regurgitating a document that is right there in front of you? So if I were you, I would dedicate my attention to applying the law, not restating. You can reference maybe a line, or yeah, but you're not going to dump sections 12 to 15 in your book. That's a waste of time. You can refer to it, you can summarize it. So does that answer your question, Wong? So the marks will go to your to brain work and application. You need to summarize the relevant sections. So I'm not going to keep you here for any longer. Thank you all for engaging. I've enjoyed today's session, notwithstanding the initial. Yeah, so thank you all and see you tomorrow. Thank you all. I'll stop sharing now. I want to see if I can stop. Yeah, and I'll stop recording. Yes.